What's up, everybody? Hopefully the mic is working now appropriately. Um, this is an interesting one. This is one that I knew nothing about until you all sent it to me. And now that I've looked at it, it's pretty wild. And it is very interesting, some of the allegations, and it's a different one, right? Which is always good for me in our discussion points, that we have a kind of a different area of law to discuss, some similarities to some other cases we've talked about. We're talking about the Lizzo lawsuit. I have to admit right off the top, I don't really know much about Lizzo. I'm sure I've heard some of her songs. I tried to look up what songs she sang. None of the titles rang a bell. But I listen to that genre of music, so I'm sure that I have heard some of her um, some of her music. So that being said, I know it's kind of the R&B type of music, and we have had other R&B singers and performers and celebrities in legal battles in the past, and we will draw some similarities there and also talk about some differences. But we have an employment law situation, right? We have assault, we have false imprisonment. We'll talk about those at the end, but we have mostly discrimination claims, religious, racial, hostile work environment type of claims. So we'll be talking about employment issues, civil issues, but different than breach of contract or an injury, negligence, different than that, right? Which we've seen in the past. So, and off the top, the reason why I mentioned I don't know much about Lizzo is I'm not a Lizzo fan, but that's not to say that I'm a Lizzo hater, right? I would say I'm Lizzo indifferent. So coming into this, I'm just looking at it with the context, knowing that it's an employment discrimination claim and trying to understand what the employment atmosphere, or what are um, the industry norms, because that's important, especially when you talk about employment law. Something that would fly at my office, I should say it the other way around, something that might fly for performers and backup dancers and backup singers on the road in Amsterdam, which we're going to get into some of those stories, would not fly here at my office or at a bank, or if you have some other kind of office job. So I think that's important for us to keep in mind, that the industry matters. The norms matter. What's appropriate matters. Now, also important in employment law, this is tough. And I've handled some of these cases in the past. I really don't like them because it's a very unfair situation, depending on the jurisdiction you're in. But a lot of what is obviously wrong and bad and immoral to us or to a lot of people does not necessarily cross the line into being illegal or even being discrimination or being a hostile work environment. So we have to keep that in mind as we go through the facts. It's a 50-page complaint. I'm going to summarize the facts, and then we are going to read some of the cause of action that point out some specific facts. And then I have read the whole thing, so I will marry the facts to the causes of action to give you more context so you can know what's going on and understand where they're coming from. Okay. So every time you read a complaint for a hostile work environment or some kind of employment case, you should come away appalled. I cannot believe that happens. How do they get away with this? That's so horrible. I would never want to work there. That is how it always sounds. That's how it should sound. The plaintiff's attorneys are the ones writing this. But you have to stay focused on what they're actually trying to prove and what is the burden. Because if you're at work and someone cusses at you or calls you a name or tells you to get out of their face or tells you suck at their job, that could be considered to you or I a hostile work environment. But legally speaking, that's not a hostile work environment. So we're going to talk. Oh, see, they said it's not R&B. Okay, sorry. I thought it was. I thought it was like, Nicki Minaj, Meghan Trainor, those types of songs. Okay, so I have no idea. I don't know what kind of songs Lizzo sings. But I did look into some context, and just for context, as we're reading and talking about the complaint, it seems like there is some. Okay, so pop. Bella just told me pop. Thank you. Okay, it's pop. I don't know the difference between pop and R&B. Okay, I guess like Boys to Men is your typical R&B. R. Kelly. I like R&B. I like pop too. So I would think like Taylor Swift when I think of pop, and Justin Bieber. So maybe it's like more stuff like that. I don't know. I'm probably just embarrassing myself here on this live stream, but I did look through some of the song titles, some of the lyrics, things like that. And there is some sexually explicit songs and some curse words in songs and things like that. And I only say that I love rap. Yeah, rap is like one of my favorite genres. I would say maybe my favorite genre. But Dave Matthews, John Mayer, Surfaces, that's probably my favorite genre, and then rap right under that. But there, I say the sexually explicit and curse word explicit stuff as well, because when you start working for someone or as a backup dancer or as a backup singer, I think you get some context as to what type of music and type of things you're going to be seeing and doing. And the reason I say is you probably are not going to be appalled if there is some language or some sexually explicit conversations at work if you are a backup singer for someone that sings those types of songs, or backup dancer that is playing those types of songs. Okay. So let's just keep all that in mind. I'm trying to build context, especially for somebody that did not know a lot about Lizzo going into this, knows a little bit about the music industry, legally speaking, but again, not an expert there as well. So let's get to the facts here. 2 backup dancers are suing Lizzo for a bunch of different hostile work environment and discrimination claims. We will get to those at the end. We're going to read through those. Apparently, there was a reality show. And again, some of the stuff I'm going to say here, which I got to be careful, but is directly verbiage taken from this complaint, not any verbiage I came up with, not any descriptions I came up with, what they are calling themselves and the shows and what the companies are called. Okay. Words like fat shaming and big girl entertainment and things like that. Okay. That's what's littered throughout this complaint. So when I make those references, not my categorization, but I'm referencing the lawsuit. So they basically, I guess, had a reality show picking her backup dancers for big girl entertainment, and they were all like plus size models and dancers. Okay. And a couple of the plaintiffs ended up going on that show and winning or being chosen to be backup dancers for Lizzo. Okay. So there are a lot of legal factors. And throughout the complaint, the lawyers try to make multiple references to the fact that these backup dancers had opportunities to work for other people and do other things, but Lizzo and her team would not let them. And while that may seem something you would just continue reading over if you were a layperson, one thing we need to think about and focus on is, were they employees or were they independent contractors? It seems like they were independent contractors. My guess is they signed some agreement that makes them independent contractors. But if you are misclassified, that can be part of a lawsuit to get you some of the protections employees get, because in most jurisdictions, employees have a lot more protections than independent contractors have. So that's going to be a question throughout this case, is can they prove that they fall more into the employee bucket versus independent contractor? And one of those descriptors is, you can't work for anybody else if you work for me. That usually makes you an employee. You use my stuff. You wear my, logo. It's like McDonald's. You wear the McDonald's uniform. You're an employee of McDonald's, right? So all of those factors go into independent contractor versus employee. And that's one of the legal things we have to think about. Next, they discuss a bunch of different things that in today's day and age, right? I really need the chat, because some of the things they discussed that they talked about as hostile work environment and offensive and illegal and harassing is their weight, obviously, anxiety, depression, fear. That one of them, I guess, was a virgin, which was a big topic of discussion, religion, and then some like sexual jokes and things like that. Some of it is in the context of the reality TV show, which I thought was interesting. One of the comments was they are proving the damages of emotional distress based on a mental breakdown that happened on the reality TV show as some kind of proof. And my first thought is this going to change reality TV if we're starting to file lawsuits that, they have a mental breakdown on reality TV? I mean, reality TV is basically one big mental breakdown. And what exactly are you signing up for? What are the agreements you signed to go on this reality TV? They had to go through a meeting with doctors and talk to them about their ailments. And they even admit that they signed away that could be seen and used by production. Just interesting, these intricacies of a case like this, where what did you agree to? Did they take it too far? What do you know going in? And where do we want to hold people accountable when things go too far? And how do we define what too far is in reality TV and in showbiz, basically? So again, a lot of those conversations were part of the factual background of what made them uncomfortable. Talking about one of them being a virgin, talking about their anxiety, pushing them past their anxiety when they knew or should have known based on how they were acting that they were having a breakdown. They did nothing to help them. There's a disability discrimination based on that as well. We're going to get to that count. Then there is a juxtaposition between something I found interesting, maybe you guys don't, of religious discrimination that one of Lizzo's employees or agents, like, I guess I don't know all the verbiage, but I think the choreographer, the person that was like the leader of the dance crew, was religious and apparently would say things like, I'm going to convert you, or I'm going to make sure you learn this, and would always talk about it and always push it and basically admonish people that disagreed with her. But then that same person is being accused of performing sex acts with a banana, talking about masturbation all the time, and being involved in taking them to a nude club in Amsterdam that we're going to get to later in the story. So the same person is basically apparently pushing religion on them and also creating a sexually hostile work environment. Interesting. Because one of the religious things she's pushing on them is that premarital sex is a sin. But then also doing the sex acts and bringing the sexual, it's very weird to me. I'm just like, oh, okay. Didn't expect that. Didn't expect that turn as I was reading the complaint. So then, one of the, and I've had these cases before, okay, and it's really interesting and can be really frustrating if I have a plaintiff that comes to me and says, this is why I feel like there was sexual harassment, or this is why I feel like there was racial discrimination. And then they say something and I'm just like, oh, that feels like an overreach. And one of the things to me that felt like an overreach was they complain about sexually explicit songs being played on the bus. So that creates a hostile work environment. Now, if you're not a fan of songs that, have that language in them and you don't listen to them, I think that's your prerogative. And I think we all have to choose what we consume. And I think it does affect us. And I don't have a problem if somebody says, I don't want to listen to that kind of music on a bus. That's fine. But that would be like somebody coming to work for me and saying that I created a gruesome, hostile work environment because we're dealing with wrongful death, catastrophic injuries, and, brain injuries and broken bones and surgeries and videos of surgeries. And I created a hostile work environment because of that content. So I just am having trouble getting to that level, at least with that complaint, right? And if you have legitimate complaints and you water them down with illegitimate complaints, we kind of talked about this with Terry Sanderson and the Gwyneth Paltrow trial. And to me, that's difficult. And that's something that you balance in the law is what actually rises to the level of a hostile work environment. It is something that has to shock the system of the jurors that see it. It has to be something that is not reasonably appropriate, that a reasonable person would find offensive, not someone on far ends of either side of the spectrum. Let me take a break here in the facts to get a few questions answered. So glad you're covering a broad variety of legal issues, TJ. I always try to. Azam wants me to rap. I don't know about that. I won't say I've never done it. There might be something out there on the in the internet world. Miranda, that was the part that was most confusing to me about this lawsuit. Most of her songs are really explicit. Is it really surprising that she wants to go to topless dance bars and things like that? Again, I think these are, and again, as we read through stuff like this, like we always do, I'm going to make some arguments to the plaintiff side. I'm going to make some arguments for the defense side. But this is going to be one for the defense side. Net Woman. In 2022, she sang Good as Hell. That's the one I remember for Grubhub. She's also known for promoting fat positivity. Okay. Thank you. I mean, I figured the plus size model type of thing was part of her brand, which interestingly enough, we've had situations where at restaurants like Hooters, there have been some kind of discrimination lawsuits because of the look that they are going for. And, you know, I have heard rumblings of some pop stars, I don't know if she was one of them, not even allowing, I don't know what the words are, thin or skinny dancers to be part of her crew. And is that discrimination? So there's all sorts of just discussions around this, but people are allowed to have brands and they're allowed to hire people that fit those brands as long as it's not a protected class. You know, I mean, that's really what it comes down to. And again, there's just a lot to think about legally here. TJ, welcome to the crew. But part of the suit is that she wouldn't let them out of the contract. That seems more employee-like. So CMD, we're going to get there. And I don't think that that's what it says. I don't think it says she won't let them out of the contract. Max Sauce, I'm not surprised. Unfortunately, independent contractors have a lot less rights, if I'm correct. That is correct. I used to work for the NBA. Unfortunately, these abuses are very common. I agree. There's no doubt that certain celebrity and big, powerful companies and people, they get you in situations where you feel powerless. And I think we need to correct those laws. And we'll talk about some of the issues here about what Lizzo and her team did. But at the same time, people have opportunities to make decisions, right? It's just, is it a constructive discharge? Meaning like, or not a constructive discharge, I guess, but is it a you're being forced into a position where you don't really have a choice. It sounds like you have a choice, but you don't really have a choice. More on that later. Bev, Peter, I noticed multiple former employees are supporting the lawsuit. Bev, jumping the gun here. This is something I was going to talk about at the end. What are the pros and cons of each litigant bringing their own action versus pooling the complaints together in one class action lawsuit? Okay, I guess I'll jump on this now since Bev asked it. The most important thing in claims like this is what are the other employees saying? Especially employees that currently still work there or independent contractors, whatever you want to call them at this point. If they say things like, no, this choreographer was not pushing any religion on us. We all knew that she was this religion or a Christian or whatever it was. She would be loud and proud about it, but we could all be whatever we wanted to be. She disagreed. We talked about stuff. She said she thought this was wrong. We didn't. And that's totally appropriate. Or are they saying, you can't work here unless you believe this? You are going to get fired if you don't agree with this. Big difference. Will the employee say, oh no, we all wanted to go out for a night of fun. It was cool. We all knew where we were going. Was it a little rowdier than we thought? Yeah. Did we have to go? No, but we wanted to. Or are they saying, none of us wanted to go to this over-sexualized performance. She forced us to or said she was going to fire us. And we were forced to take part in the debauchery that made all of us uncomfortable. So you start to imagine how important those witnesses can be in describing what the work environment was actually like. And when it comes to class actions versus individual lawsuits, you can't just say, all right, 5 of us want to do a class action. It has to be numerous enough to where it makes sense for judicial economy to bring you all together as a class. There are factors that you have to certify and get certified as a class before you can become a class. And each jurisdiction is a little bit different. But I don't know if there's enough. I mean, the 3 of them is not enough for a class. So they're just co-plaintiffs in one lawsuit. You could have a bunch of co-plaintiffs in one lawsuit. If you're all multi-jurisdictional and things like that, that kind of goes to why you need to be a class if there's enough of them. So there's a lot of factors that go into making somebody a class. It's just like any other workplace, right? You're not supposed to talk religion, politics, definitely not sex. So no, it's not like every other workplace. Each individual workplace has its own industry standards, number one. Number two, it's not that it's illegal to talk religion, politics, or sex. It's what environment does it create? You don't, it's not a don't ask, don't tell, or whatever that, it's not, that's not what it is. People are allowed to know if you're whatever you believe, right? They're allowed to know that. The difference is forcing it upon them, forcing them to believe it, firing them if they don't, creating an environment where there are negative employment actions based on their race, religion, creed, sex, whatever, all the protected classes. Amber, I was going to go on a reality TV show, and the contract I looked over was very in-depth about a lot of personal things in your life. You sign away a lot of privacy rights. I did not do it. And Amber, that's your prerogative. And I think that's great that you read it. I think most people in today's day and age are doing anything they can to be famous and to get rich and famous and to have all of the things of that life. And I think they're willing to sign away a lot of things. And I think we have to balance, and I'm not saying this applies to these plaintiffs, but I will say I have seen cases where you don't get what you want, and then you go back and say it was unfair because you didn't get the fame that you were looking for. And there are some paragraphs I think the defense will use that in this case to say, and we will get there. Daria, question, why does her lawyer include this into the complaint if you as a lawyer see it as a weak point? What makes them think it's strong? I think at this point, sometimes lawyers try to stack as many things as they can. So if they're trying to show sexual harassment in a hostile work environment, they're trying to say, look, they talked about sex. They did sex acts in front of them. They had sexually explicit music on the bus. They went to this nude bar in Amsterdam, which we haven't gotten to yet. And I think he just thinks it's one of many things that he's stacking up there. And I'm just saying, the way I look at it, I would have left that one out personally. Net Woman, thank you for the super chat. 2 of the 3 ladies were on TMZ Live yesterday, and they said that she gave preferential treatment to the dancers that were up for anything. They claimed that she never threatened them, but she would treat them different. Sorry about saying fat. I'm big too. No. And again, they use a lot of this verbiage. It's all love here, for sure, regardless of what someone looks like, size, race, religion, whatever it may be. Okay. We're all hanging out here learning about these legal things together. And it's important that we have a bunch of different perspectives. But here's what I'll say. So this is where it gets sticky. They felt like, or they said, this is subjective, that she gave preferential treatment to the dancers that were up for anything. So this could be a jury question, but does a boss liking certain employees more than the others, is that discrimination? Is a boss not supposed to think certain employees are better than others? This is a tough one for me. And usually the courts are not going to condemn someone for having employees they think are better. And I'll just tell you this as well. Every lawsuit like this, every employment lawsuit, every wrongful termination, every wrongful discharge, every discrimination lawsuit, the employer says the employee sucked anyway. We were going to fire them. They weren't good. It had nothing to do with this. It was all performance-based. And then the employee will say, I cannot tell you how many people told me this. I did a lot more of this early in my career. I don't do it anymore. But employees say every time, I was the best employee. I was outperforming everybody. And they still fired me. That's why it's clear it's discrimination. And some of it is subjective. The best ones were, I'm a car salesman. I sold the most cars last quarter. That's easy to prove, right? And the cases that we won the biggest on, we had emails, documents in writing where they would say the most horrible things directly at a person. And again, we're talking about at banks and big Fortune 500 companies, which I don't think they're going to apply quite the same office standards here. Oh, Lizzo made a statement on her Instagram. Okay, I have not seen that yet. All right, let me get back to the facts and the overview. They admit that they were only paid while they were on tour, which would be more like an independent contractor. And they were mad that Lizzo would not tell them. And this is some of the stuff about, somebody said Lizzo would not let them out of the contract. They are saying that they were mad that Lizzo wouldn't tell them if they were going to be on the next tour. And I can understand that. I would want to know, am I going to get paid? Am I going to have a job, in the fall? Am I going to have a job next year? Everybody wants that. And that's where the industry comes in. If I have a paralegal here and I say, I mean, you can't have contract paralegals even. I can bring in a paralegal and say, hey, we just got this case. I needed another paralegal. You can work for this case. I don't know if I'll keep you past that. There's nothing illegal about that. I don't like doing that. I've never done that. So I like having, hey, we're hiring you. You're working here as long as you want to work here and as long as we want you to work here. In Florida, it's a right to work state, so either party can break that at any time. But when you have something like this where you have a tour that you need dancers for, I don't find it legally inappropriate or even morally inappropriate to say, maybe you will be back for next tour. Maybe you won't. Maybe we'll get a better dancer. Maybe you were more trouble than it was worth while we were on tour last time because you had to have a nicer hotel room or a nicer spot on the bus or whatever it may be. So that's always interesting to me. I don't think that's unfair that they didn't necessarily know if they were going to be back for the next tour. Now, here's where we're going to bring up our first part of the lawsuit, just because I think the language is really interesting. Let's look at this together. All right. Page 12. Paragraph 32, I think, is where I wanted to go next. Let me check my notes here. Yeah, page 12, paragraph 32. Here we go. On or about February 23rd, 2023, plaintiffs performed with Lizzo at a show in Amsterdam. After the show, Lizzo invited the dancers out with her on the town. These invitations were not unusual, and attendance was not mandatory. But it is well known that dance cast members were expected to endear themselves to Lizzo. Lizzo often mentioned that she had eyes and ears everywhere and only wanted good people with good energy around her. Those who attended after-party events with Lizzo or that Lizzo planned were often favored, selected to perform with Lizzo at shows outside of regularly scheduled tour dates, and were widely considered to enjoy greater job security. By not attending, dancers not only risked losing out on being selected for these additional shows and therefore additional income, but also risked being ostracized from the group, putting their continued employment on tour in jeopardy. Okay. Do I condone these Amsterdam places? First off, you couldn't catch me dead in there. You couldn't pay me enough money to go there. I don't care what the offer was. I would say pass. Thanks, but no thanks after you hear the description of what goes on in those places. But how is this different than any other job? Maybe you're saying the content of what they're doing, which I agree, but they say it is not mandatory. They do not have to go. They do not get fired if they go here. That's like if you don't have a job, right? If you don't have a job and I'm taking out 10 law students and we're going to a steak dinner and I say, come have a steak dinner, come hang out, let's get to know each other. And I hire the one I like the best at dinner. Well, if you don't like steak and so you didn't want to come to dinner, so I don't hire you, is that discrimination? No, you still could have come to dinner and not eaten steak. Or you could have said, oh, I don't like steak. I really don't want to come to dinner. Can we do something else? And maybe I would have said yes. Maybe I wouldn't have had time. But I didn't make the decision based on who came to dinner, right? You made the decision based off the interviews and how you talk to them. It's like if somebody's unavailable on a certain day for an interview because of their religion, but you make the hiring decision that day, the law does not require you to make sure that you take every single thing into account when you make decisions as to who you think is good for the job. There has to be reasonable accommodation for disabilities and for religious gatherings and things like that. But no. I'm not saying, Madras just said, are you saying they should have subjected themselves to the banana eating shenanigans? Here's what I will also say, though. Weird stuff happens at a lot of jobs, and they could have quit. There's nothing that I've seen so far that says they couldn't have quit. Now, maybe they felt like they couldn't quit, but you can quit and not take the money as well, right? Like, do you think people should subject themselves to sitting in cubicles in dark rooms for 8 hours a day? But people do it and they sign up for it. Once you see how horrible it is, I believe you should be able to quit. And there are certain employment contracts that you have to show that there's cause for you to breach. And I think that that would be cause, if that's what you're asking. And these things are really, really factual questions, right? It's not a lot of bright line rules here. And to me, I just think that we've got to be careful about, because here's what people do. If you start to do this, people start lying. They start having pretexts. They start saying, they start having no relationship with anybody that they work with. And that's where you spend a lot of your time. I think you'd like to get along with your bosses. Netwoman said 2 were fired and 1 quit. Yes, we'll get to that later in the lawsuit. I just think this stuff is hard. And I think we have to think through it from everybody's perspective. And again, not how I'd run my business, not where I'd want to work, not who I'd want to hang out with. So don't at all think that. I'm just applying it to lots of different jobs that you could or could not sign up for, not that you have to. But again, I think some of the stuff they were subjected to was horrible. And I think they could potentially prove this was a hostile work environment. I think that if they were forced to be subjected to all of this stuff over and over and over again in order to keep this job, again, like the Amsterdam stuff, but it's paragraphs like this that make it tougher, that say they didn't have to go. If they were forced to go to these Amsterdam clubs, hostile work environment, absolutely. Now, the question is, based on this verbiage, were they, somebody just had a good question. Were they constructively forced to go? That's, I think, the question. They said that we didn't have to go, but did they really mean what they said? Because everybody who went got paid more. Everybody who went had better opportunities. So you actually had to go. It was part of the job. So if they were pressured to go and had to go and they can prove that, then I think they have a really good case. And I think, again, the other employees can provide context for that. Now, some other stuff that happened, again, here, pressuring the person, and I don't know why, what personal decisions, and I feel bad talking about the fact that she was a virgin and made that decision for whatever it is, but they pressured her specifically to do things at these clubs. There were nude people doing, just say, debaucherous stuff up on stage. A lot of them were uncomfortable. A lot of them didn't want to be there. Here's another interesting paragraph for context, okay? So after all of that, they asked, because they were not allowed to take other jobs, while they waited, could they be on some kind of retainer? And they asked for 50% of what they would make while they were working for the months that they were not working, so they could reject other jobs. Seems fair for the employees to ask. Paragraph 41. On or about March 16th, the last show of the Europe leg of the special tour was played. Before the show, BGBT accountant Ashley Joshi sent an email responding to the dancer's retainer request. In the email, she offered a retainer of 25% of the weekly tour rate, exactly half of what the dancers requested. Not unusual. You ask for 100, I offer 50, right? It's a negotiation, money, business. Additionally, Miss Joshi took the opportunity to scold the dancers for unacceptable and disrespectful behavior while on tour, stating that it was cause for termination. Nowhere in the email did Miss Joshi explain what she or BGBT deemed unacceptable and disrespectful, only that the dance cast comprised of full-figured women of color were ever spoken to in this manner giving plaintiffs the impression that these comments were charged with racial and fatphobic animus. This email marked the beginning of a strained relationship between the dancers and management. So a couple things to pull out here. Here's where we start to get the racial discrimination undertones. I think they're going to have to provide more objective evidence than reading into something like this potentially. Also, because it was not specified what the unacceptable and disrespectful behavior was, it kind of leaves it open to interpretation, which then means in a deposition, the employee could say, oh, that's not what I meant. I meant this. I meant how they were acting on stage. There were some comments about you can't drink alcohol before you dance, and they complained about that. It's like, well, I don't want you drinking alcohol before you come work in my office. But also she was saying, well, we weren't doing that. Well, if you weren't doing that, then you shouldn't care if somebody tells you not to do it. But here's another interesting part. And if I'm a defense attorney on this case, this is something I point out. According to plaintiff's own complaint, when did the straining of the relationship begin with these dancers? They didn't say it was a strained relationship when they were pushing religion on them. They didn't say there was a strained relationship when the banana stuff was happening. They didn't say it was a strained relationship when the Amsterdam stuff was happening. No. The beginning of the strained relationship came when Lizzo and her team didn't pay them the money they asked for. They offered half the money they asked for. That's when the strained relationship began, according to the plaintiffs. A very common defense argument in cases like this is, it's all good until the money changes. So, I don't know. Again, I don't know anything about this. Okay. Factually, I don't know who's telling the truth, who's not telling the truth. I don't know what happened in Amsterdam. I don't know what happened with all this, but the plaintiff's own timeline says that that's when the relationship started to be strained. They were blindsided by these allegations, and then they continue going on saying that they continued to treat women of color worse, and fat shaming. And Lizzo complained about their performances, but not until after this. And again, the drinking and things like that. And one of the dancers, I guess, had a bowel movement while being pushed too hard because they had to re-audition and retry out because of the alcohol accusations and other things going on. And I guess they're saying because of this money issue, it was unfair that they had to retry out. Again, I sympathize with them. I don't want to retry out. But guess what? Every time a new client calls me, we've got to talk through and they've got to figure out if I'm the right person. I retry out every time somebody hires me. And if you want the best at something, I don't know why they did it, right? And again, a lot of times in these cases, it's a she said, like it is here, where it's like, well, they said that they wanted us to retry out because we had to do better. But in reality, it was in retaliation for us asking for more money or for us complaining about their discrimination. And that's something that has to be proven with other facts, right? And other testimony. So let's get here to the actual causes of action and how they work together. And before we get there, actually, let me answer a few more of your questions. Here's the first cause of action. All right, let's get to a couple questions here. CMD, could an employer ever reasonably require an employee to go to a party with them, an after work event? Absolutely. Absolutely. If you're an hourly employee, you have to get paid for it, but you can require attendance at a party. Yeah. I should say in most jurisdictions. I don't know every jurisdiction everywhere. Jacqueline, welcome to the crew. Who dat? Lisa, what if an employee has regular evaluations showing excellent work? Does that help support a claim? Yes, but in right to work situations, you can still fire them even if they're a good employee. But this would absolutely help. It's like 5 stars every quarter, 5 stars. Actually, this review was just done 2 weeks before you fired her. 5-star review, Then she complains about, you're trying to back off her work because she told you she was pregnant and now you fire her. We've used timelines like that in pregnancy discrimination claims and been very successful with them. That it just so happens the timeline lined up when she told you she was pregnant. Absolutely. And work performance reviews absolutely help. Edmo, what they say and what is implied and will happen if you don't participate is not the same thing. Is that legal? Again, did she ever fire people that didn't go? Can they prove that all the people that made more money or continued on tour went on those things and all the people that didn't? Because we've had stuff like this where they do mass layoffs. And guess what? Some people do fit into the category that you want. So, for example, here, it would be if they could prove as the defense, like, we fired 10 dancers. 8 of them never came to the club with us, but 2 of them was at every single time we went to the club. It had nothing to do with that. We fired the 10 worst dancers. If they have evidence like that, it kind of knocks the implied difference in treatment. But again, if it's like these 4 were always at the club, these 4 are the best dancers and the highest paid dancers and on every tour, these 10 never went to the club and they only were one and dones. It depends on what the evidence shows. Jessica, environment matters. Could you sue for sexual harassment if you work in a strip club? Absolutely. Absolutely you could. Now, the sexual harassment can't be, I'm expected to get on stage and strip down and dance. But absolutely your manager, the way they treat, I shouldn't say you, this person's manager or the way they treat them or speak to them or touch them. Absolutely. Rachel Mills, should Lizzo have had enough foresight to not make this her workplace environment? I think everybody should have this foresight that you do not want this to be your workplace environment. But I mean, again, and that's kind of it does have a little bit of a cultish feel to it, like the R. Kelly stuff on a much more minor scale. But it's like they said she was over-sexualized with her boyfriend in front of them and would take people back in back rooms. And again, the banana stuff and the clubs. And it's like she created this weird environment that she probably wanted people that liked that weird environment, just like R. Kelly. Maybe it felt forced. A lot of fact questions up that we can't know at this point. Beverly, can athletes not be benched for poor performance? Of course they can. But they can be benched for other reasons too, right? And it just goes about how you prove that. Mrs. Wilkins, if what you were being asked to do is morally or ethically against your code, leave. The allegations don't point Lizzo and her brand in a good light. But was it criminal? No, this is not a criminal case. This is just civil. This is about money. And we'll get to that when we get to the prayer for relief. Kenny, I don't see an issue with some sort of exclusivity clause when you're doing something dangerous like dancing. A lot of dance moves are dangerous. I haven't seen the agreements, right? But to me, almost what it sounds like is if you go work for somebody else, that's fine. We're not hiring you back. Which again, in independent contractors, you're allowed to do, especially if it's competitors. But also, if you go get hurt doing something else, we're not held to your contract. We're not hiring you back. So people have to make those decisions. I would guess, I don't know, but I want to dance for the biggest and best celebrity that probably is going to get me the most money and most fame and biggest opportunity to get in front of the most people. So I'm going to reject the lower ones if I have to choose between. I don't know if that's industry standard. I don't know if that's going to be enough to make them employees. Those are questions that are going to have to be borne out from the facts. All right, let's read the causes of action here after I get a sip. First, hostile work environment for sexual harassment. The conduct of defendants Lizzo, BGBT, and Ms. Quigley created a hostile work environment for plaintiffs, making the conditions of their employment intolerable in direct contravention of various statutes and state law decisions, including but not limited to these. Plaintiffs were subjected to hostile work environment due to, including but not limited to, defendants' repeated exposure of plaintiff to nudity against her will and pervasive habits of sharing lewd fantasies and tales of sexual encounters. Now, this is also factual intensive, right? Because is this people telling stories about their fantasies to their friends? Or is this some creepy sit in a room and we're going to tell you all our sexual fantasies? And then saying being exposed to nudity against their will? That's going to have to be language proven to a jury. What does against your will mean? You can come if you want to, but you don't have to. You're going to lose your job if you don't come. That could be considered being forced against their will, I think. Depends on how that's going to be proven. Such harassment was so severe and pervasive that it altered the terms and conditions of plaintiff's employment, creating a hostile, abusive work environment and making their working conditions intolerable. Said harassment was sufficiently extreme and totally pervasive to amount to a change in the terms and conditions of plaintiff's employment. Now, if an employee is forced to do horrible things, like what happened at the bar, forcing them to touch, and I shouldn't say forcing, but it was like peer pressure to a point where I think it could be considered forcing them to touch or do things with people on stage. Absolutely. And I think they should have called a lawyer right at that point and pushed for change or pushed for a lawsuit or sued them there. Timing is so important of these things. Throughout their employment, plaintiffs were exposed to an overtly sexual atmosphere that permeated their workplace, as explained in great detail above. And so this is where I think why they add things like sexually explicit songs on the bus, because it has to be, these are all elements of sexual harassment. It has to be an overtly sexual atmosphere that permeated their workplace, not just once in a while somebody would talk about it. Plaintiffs were pressured to participate in the nude photo shoot. That's true. That's another one. Again, there's going to be arguments on both sides. That's horrible. I don't think you should be forced to do that. What's the definition of force? Did they have the ability to say no? Those are going to be factual questions. Additionally, Dancecast captain, defendant Ms. Quigley constantly regaled the Dancecast and plaintiffs with luridly detailed stories about her masturbatory habits and sexual fantasies. Okay. Lizzo herself pressured her employees to attend outings where nudity and sexuality were a focal point and disregarded any apprehension. Again, they have to determine, was this part of the workplace? Was this part of the work environment? They hounded Ms. Davis to touch a performer, despite saying she didn't want to. She shouted at her security guard to remove his pants while being whipped. Again, weird, creepy stuff I'm not interested in. But were they forced to go? Was it part of their workplace environment? Those are the legal questions that we have to try to focus on, even if this, is a shock to our senses. They timely filed the discrimination complaint. As a direct result, plaintiffs have suffered and continue to suffer damages, including losses in earnings, other employment benefits, physical injuries, sickness, emotional distress, medical expenses, future medical expenses, attorney's fees, and costs. Such actions justify the imposition of punitive damages. That's damages that punish. And they say this goes so above and beyond. It's so horrible that we need to punish Lizzo so that she and other similar employees will be deterred from doing similar actions with their employees and at their workplaces. That's kind of how punitive damages work. This is a wrongful intention by defendants committed the acts alleged herein maliciously, fraudulently, and oppressively with the wrongful intention of injuring plaintiff from an improper and evil motive amounting to malice and in conscious disregard of plaintiff's rights. The second cause of action is basically failing to prevent that. So Lizzo failed to prevent the sexual harassment environment, all very similar to what we've already read. Third cause of action, the religious harassment. So different than religious discrimination, meaning you're fired because of what you believe or fired because you don't believe what they want you to believe. This is religious harassment, similar to sexual harassment. They created a hostile work environment. They were subjected to that. It was so severe and pervasive that it altered the terms and conditions of plaintiff's employment, creating a hostile, abusive work environment, making their conditions intolerable. It was daily. Ms. Quigley loudly and unabashedly attempted to impress her religious beliefs on everyone on tour. When any member of the Dancecast expressed disparate beliefs, Ms. Quigley would show extreme displeasure and occasionally would lash out in anger, berating those who disagreed with her. She kept tabs on Ms. Davis's virginity, made it known that the only way to be a pure Christian woman was to abstain from premarital sex. She also attempted to strong-arm Ms. Rodriguez into conforming with her dogmatic beliefs, continually make it clear she did not want to share Ms. Quigley's beliefs or appreciate Ms. Quigley's proselytizing. She became irate. It was their personal mission to minister to Miss Rodriguez and to make her change her behavior. They filed the complaints. It resulted in damages and punitive damages. Fourth cause of action was failing to prevent, again, the harassment. What's interesting to me is, I could be wrong, but again, this juxtaposition between the same person being overtly sexual and also forcing religious, purity on you, sexual purity on you. What was required from the dancers? Because also, like how they talked about Lizzo, this just seems weird that they felt like they were berated for certain sexual acts, yet it was such a sexual atmosphere, overly sexualized atmosphere. It's just, this one's hard for me to wrap my head around. Okay. Where is the next one? All right. This is the fourth cause of action. They did not prevent it. Okay. Racial harassment. Fifth cause of action. They created a hostile work environment, making it intolerable, violating statutes. They were subject to this environment due to, including but not limited to, the management deriding Ms. Williams, Ms. Davis, and other Black members of their dance team as lazy, unprofessional, snarky, and generally having bad attitudes. This is always interesting when race, gender, size is also shared between the person hurling the racial insults and the person receiving them. Some people think that can't happen. Legally, it can. You can be racially discriminated against or harassed by someone of the same race. That is legally possible. None of these same allegations were leveled against dancers who were not Black. Okay, to put something like none of these allegations is important. Now, if all the dancers are Black, that's not really fair. But, and again, that ratio actually matters, because if there's like one white dancer and 50 Black dancers, and this was hurled at 5 of the Black dancers, the jury starts to see, well, why wasn't it hurled at all 49 if it was about race? And you can't just say it wasn't hurled at the one white dancer. You can't say it was only because she was white, usually, legally speaking. It would be like if there were 20 dancers, 12 of them are Black, 8 of them are white. All 12 of the Black dancers were said to be lazy, snarky, having bad attitudes, and none of the 8 white dancers were. Now, theoretically, that could be something that was true or whatever, but you could understand there how you have a much better argument for racial discrimination. And the statistics and the numbers and how people are acting matters. After Miss Williams was fired in a hotel lobby in front of the entire dance cast, and Miss Rodriguez confronted Miss Gugliotta about how unprofessionally she handled the terminating of Miss Williams, Miss Gugliotta responded, "We've never had any problems with you," seeming to imply that Miss Rodriguez, one of the few members of the dance cast that was not Black, was not painted with the same generalization or generalized and unfounded criticisms as the Black members of the dance cast. They're going to need more than that. I'll just say they're going to need more than that. I think if it is true that these insults were hurled just at the Black members and not at any of the non-Black members, that's a pretty good argument for racial discrimination. Such harassment was so severe. Yeah. And somebody said, I respect Rodriguez for resigning over what happened. I agree. And I think that's going to be huge for them. That's going to be huge for this lawsuit, that she was not fired. She chose to leave because this was so bad. I think that's huge for them. Such harassment was so severe and pervasive. Again, those are the elements. It has to be so severe and pervasive to change their employment conditions. Hostile, abusive environment. And then they suffered damages. All right, the next one, and this one's interesting, disability discrimination. At all times, they had 5 or more persons. Okay, so they fit under the statute. You have to have a certain amount of people to even be able to be sued for this disability discrimination. That's a whole other video. We're almost at an hour trying to get through this here. This cause of action is brought prohibiting termination of an employee. Okay, prohibiting a termination of an employee from employment or to discriminate against employees on the basis of their pregnancy or disability. It is very interesting that pregnancy is considered a disability. We file those claims under this Disability Act. Again, separate for another video. They knew about Ms. Davis's struggle with anxiety, depression, and binge eating disorder from a psychological examination she submitted before going on the show. So they're saying you had knowledge of this disability, anxiety, depression, and binge eating, before the show even started. Yet, they made her anxious during her re-audition that she believed she was not allowed. Again, she believed she was not allowed to leave the stage. Why did she believe that? Was she told that? Was that just pressure she put on herself? How did we get there? That's a really important question. She lost control of her bladder, and after that, it should have been wildly apparent that she was grappling with some stressor in her life. Despite being on notice of this, Lizzo and Miss Scott held a meeting which they interrogated her about her health and well-being until she felt compelled to disclose further details about her conditions. While interrogating her, they only seemed interested in finding an explanation as to why she had gained weight and made Miss Davis believe that if she were to take time away from rehearsals to treat her binge eating disorder, she would lose her job. A lot of subjective things that they're going to have to prove, right? What made her believe she couldn't do that? Did anybody say it? Was anybody else ever allowed to leave to deal with a mental health issue? Their adverse actions were in retaliation for her talking about her disability. Again, an analogy would be, in my cases that we've had, when you tell your employer you're pregnant and 2 weeks later you get fired, that's in retaliation for your, disability. I don't like calling pregnancy a disability. It's a blessing. But legally that's the category it falls under. She filed her notice of right to sue, exhausted administrative remedies. So there's a whole other interesting aspect of this, that you file this, and if it's so bad, the federal government will pick it up and litigate these cases for you. If not, you get what's called a right to sue letter, which you have to do it yourself. Seems like this is going down path too. Now, obviously, all the cases I had, well, not all of them, 99% of the cases I had also got right to sue letters. But it's just interesting that you do have to go through that process. All right, seventh cause of action, intentional interference with prospective economic advantage. Again, this has to do with money issues and whether or not they could have gotten other contracts, putting them on a soft hold. And by the way, a soft hold you can break and say, no, I'm out. I'm going to go get a different contract. So again, how much were they held to those contracts? Then assault. And this one's interesting. Ms. Davis filed a cause of action for assault. Sorry, Ms. Rodriguez, against Lizzo, because when she quit, she became increasingly more angry. She started yelling profanities. Approaching her aggressively, yelling profanities, cracking her knuckles, balling her fists, preparing herself for an attack. Apparently preparing herself for an attack. You're lucky. You're so effing lucky. And she believed she intended to hit her and would have done so if other dancers would not have intervened. That's the assault cause of action. And then false imprisonment, where they interrogated Ms. Davis, forced her to stay there, forced her to give them their phone so they could look through it, because they said they heard that some dancers like Ms. Davis were recording these meetings, which again is a felony in a lot of states. But they told them they couldn't record them. They took their phones. They took Ms. Davis' phone, looked through it, forced her to stay there, answer questions. She felt like she couldn't leave. False imprisonment. Those seem like potentially criminal charges, but again, we'll see how this continues. And if you stick till the end, I'll tell you how I think this case ends. Prayer for relief. They want damages, lost wages, loss of earnings, deferred compensation, other employment benefits. Again, independent contractors don't get all those employment benefits, so I think they're going to try to prove they were employees. For general damages, for emotional distress, for special damages, reasonable medical expenses, for punitive damages, for lost wages and interest on that, and attorney's fees and costs. That's what they are asking for here in this complaint. All right, Bella has sent me the Instagram post. Let's go ahead and share it. All right. These last few days have been gut wrenching, difficult, and overwhelmingly disappointing. My work ethic, morals, and respectfulness have been questioned. My character has been criticized. Usually, I choose not to respond to false allegations, but these are as unbelievable as they sound and too outrageous to not be addressed. These sensationalized stories are coming from former employees who have already publicly admitted that they were told their behavior on tour was inappropriate and unprofessional. Again, referencing that email that was referenced in the complaint. As an artist, I have always been very passionate about what I do. I take my music and my performances seriously because at the end of the day, I only want to put out the best art that represents me and my fans with passion. Sorry, with passion comes hard work and high standards. Sometimes I have to make hard decisions, but it's never my intention to make anyone feel uncomfortable or like they aren't valued as an important part of the team. This is what every employer says. I'm not saying she's wrong. She could be very right. But basically every employer says like I have high standards. I want the best employees. If you're not the best employee, sorry, but this is bitter. You're being bitter because I fired you. That's what they all say. I am not here to be looked at as a victim, but I also know that I am not the villain that people and the media have portrayed me to be these last few days. I'm very open with my sexuality and expressing myself, but I cannot accept or allow people that use that openness to make me out to be something I am not. There is nothing I take more seriously than the respect we deserve as women in the world. I know what it feels like to be body shamed on a daily basis, and I would absolutely never criticize or terminate an employee because of their weight. I mean, it seems believable, right? I feel like she could convince a jury of that. I'm sure there are comments online that are nasty about her weight because I know how comments can come online, right? I like to share some of mine sometimes. I'm hurt, but I will not let the good work I've done in the world be overshadowed by this. I want to thank everyone who has reached out in support to lift me up during this difficult time. All right. So that is the lawsuit. That is the response. I'm going to answer your questions and then let you know how this ends. Not because I'm a genius, but just because I have a very, 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 very good idea of how this happens. Millennial Me, please discuss the toxic media backlash on your pod. Okay, I will have to look for it. I really haven't gotten a lot about this except from you guys. And none of you guys have seemed too like toxic or have made up your minds when you send it to me. You're like, this is crazy. This is interesting. How do you think this is going to go? How does this work? Blessed Mom from Texas, welcome. Mindy, Peter, how do they prove their allegations? Pictures, videos. Yes, pictures, videos, emails, statements, their own testimony, testimony of other dancers, testimony from the security guards they talked about. Mujer, wasn't the re-audition for 12 hours without a break and the reason the dancer lost control of her bladders? Yes. And they talk about that. Now, what does no break mean? What does for 12 hours straight mean? Because sometimes you see allegations in a complaint, they're legit and you prove it. Maybe they can prove it with a Fitbit or their phone or their Apple Watch. But again, does a 12-hour audition without a break, do you think, I don't know the answer to this, okay? I don't know the answer. I'm asking. Honestly, I'm just genuinely asking. Is that abnormal in the world of these celebrities? Taylor Swift just gave $50 million to the crew. Very generous. My guess is they had some 12-hour days. Now, what's the definition of a break? Could they not sit down? Were they dancing for 12 hours? Could they not use the bathroom? I don't know. Because it didn't necessarily say maybe it did say they couldn't use the bathroom. I can't remember, but they said she lost control of her bladder. Not like she had to go so bad she couldn't hold it. That's different, I think, as a definition. It is really interesting. I don't know because that alone does not make it a hostile work environment, sexual harassment, religious harassment. That 12-hour re-audition does not make it that. And who had to re-audition? Was it everybody or just people who didn't go to the club? Blessed Mom. Peter, absolutely love your channel. Can you take a case for me here in Texas? It's for my 9-year-old daughter. Shoot me an email, lawyeryouknow@gmail.com. I don't talk any case specifics or give any legal advice or anything like that on the channel. I give consultations to people if they have injury cases or wrongful death cases for the type that I handle. So yes, email me. And if it is the type of case that we handle, I'll be more than happy to talk to you about it. She wore nude underwear for the photo shoot. Cardi B from Netwoman has a battery case against her for nailing someone in the audience and it ricocheted and hit someone else. Yeah, I saw that. And the person like threw water and then she immediately threw the microphone. It's wild. It's a wild world out there. But I heard somebody else say, what do you expect when you go to a Cardi B concert? So it's all this like inherent risk and what do you expect in the world of, the R. Kellys of the world. And I mean, that was obviously a criminal enterprise. It ended up coming out, the jury decided. So I don't know. I don't want to be in that world. I know that. But I know there are people that would say it's the same thing like with the NFL. Knowing the risk of concussions, I will say, if I was a good enough quarterback, which is what I played in high school, I would have taken that risk and played in the NFL. I know that it's a real risk. I know that paralysis, that major injuries are a risk. Not to say I shouldn't get insurance if I get paralyzed or anything like that. But I'm just saying for me personally, if I was good enough, I still would have taken that chance. And I think there are some dancers that if they're good enough, they would take the chance to go and be a dancer on one of these, crazy high profile celebrities, even if it's 12-hour days. Maybe I'm wrong. Aaron, the COAs differ from their earlier descriptions. It's more legalese and legal speak. Azam, 1 hour. It has been a while since you did a live stream, more than an hour. Thank you for the breakdown. Respectful as always. You're the best. This one's tough. I'm really trying to, and I'm trying to understand. But again, there's so much we don't know because we need to see how these facts bear out. One side's going to say, this is what happened. The other side's going to say, no way, that's not what happened. Lawyer, she called them employees in the past. How could that impact this? It could matter. It could matter, or it couldn't, because people can be misclassified all the time. If they signed independent contractor agreements, that's where we start, and then we get the context and the factors from that. Pollyanna, welcome to the crew. You're a genius, Peter. I learned a lot from you. Well, I'm glad we can all learn from each other, but I think you're too kind, as per usual. Okay, so to go out here on Azam's super sticker, here's what's going to happen in this case, my bet. And I hope a lot of you have already figured it out by now. This case is going to settle out of court. That is my bet. That's where I would put my money. I think there is enough here to potentially scare Lizzo. If she does lose, it could be big money, but there's enough risk that I also think the plaintiffs could just lose this case outright. There are definitely a lot of arguments and defenses the defense are going to have that we talked about today as we went through the video. And usually where there are issues on both sides, but there's also some legitimacy on both sides. Usually civil cases like that settle outside of court, even when you don't expect it. Think about Johnny Depp and the punch that occurred with, somebody on set right after his huge win. Everybody says he's going to keep fighting for justice, but he paid. Doesn't mean he did anything wrong. It just means it wasn't worth the risk, or it was worth it to just pay and get rid of it. Or maybe confidentiality or whatever it may have been. But they found it was worth it as a business decision to settle the case, as most civil cases do. All right. Michelle asked, when do they go to a courtroom? Probably not for a while. So many hearings and depots and everything is done by Zoom. But eventually, if it goes to trial, it'll be in a courtroom. Sometimes they'll have hearings in courtrooms, obviously, still too. So we don't know. Beverly, expensive mistake. She'll definitely learn a tough lesson here, though. Hopefully she makes it a better work environment for everybody. That's all I can say. Hopefully some good does come out of it. All right. That's all I've got. Appreciate everybody for joining me. I love you all. Thanks for sending this to me. So many people sent this to me, and that's, how we come up with our content. You guys drive the content, and what you're interested in is what I do. So I appreciate you all. I'll catch you on the flip side. Keep me posted if new things come up in here. If you have more questions on Instagram and Twitter, check us out there. More shorts and clip outs coming this week. Pumped. More BA lawyers are coming. The people asked. We're going to answer more BA lawyers. Thank you guys so much. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.